SABC, together with the Department of Justice and Constitutional Development, bring you the final verdict. In the pursuit of justice, we are all equal before the law. These are some of the stories that have led to the final verdict. Wrongful eviction is an ever-increasing issue in lower-income areas. Residents, tenants, and landlords alike are not fully aware of the rights they have and the legal processes to be followed when dealing with an eviction or ending a rental agreement. The Constitution provides for the right to have access to adequate housing and states that no one may be evicted from their home without an order of court made after considering all of the relevant circumstances.
The South African Constitution guarantees a right to housing, but the Constitution also recognizes that the government cannot freely give houses to everybody at the same time. The history of evictions in South Africa is a very long history. In particular, it started with the farm workers, who generally are vulnerable people that used to be dumped onto the streets and with no alternative accommodation. The law developed from that end to make sure that there is no longer any eviction of people without a due process being followed.
It's Mr. Tabisha, Ms. Morale. Can you please open the door?
Mr. Tabisha.
Ms. Morale, I need you out the house now, please.
What? You want me to leave now?
Yes, if you can't pay the rent, we need to make space for someone who can.
But sir, I explained.
Ms. Morale, your personal problems don't concern me. You need to leave.
But sir, I have nowhere else to go, and my child. It's very late, Mr. Tabisha. Can't we talk about it tomorrow?
No, you need to leave now. Either you do it yourself, or we can do it for you.
Lerato, who's here, my baby? But sir, please, look at us. Where are we going to go at this time? Just give me a chance, Mr. Tabisha, please. I'm begging you, please.
I have every right to do this. So take what you can and get out. I don't want to have to throw you out.
Okay, sir.
Both sets of rights, the rights of the occupiers and the rights of the landowners, do to a large extent come to a loggerhead. The owners have the right to the use and enjoyment of their property, and the occupiers have the right not to be evicted without a court order. Now, obviously, where people wish to exercise that right, there is a certain procedure that needs to be followed.
Firstly, there must be a notice that is given to who will be persons that will be evicted, and that notice must also indicate that those people have got a right to legal representation. That notice must also be given to the local municipality to ensure that if the landlord doesn't have the means to provide an alternative accommodation, the municipality, within its own means as set out in the Constitution, must be able to provide the alternative accommodation.
Lesego Morawa sought free legal advice from the law clinic at a university near her home. On her lunch break, she met with law student Tebogo Hadebe, who tried to help her to understand her rights and the legal procedures that had to be followed before she could be legally evicted.
Supervising attorney Ms. Campbell wa tswang university ke yena a tla o emela khotho bekeng e tlang. Ha jwale ke batla hore re shebe dipotso tse ding tse re sa kang ra fihla ho tsona ha o no tlile ho nna law clinic.
Ho lokile, mme ke tshwantse re ke boele mosebetsing haufinyana.
Re kentse kopo ya hao lekgotleng la magistrata tlasa ditsamaiso tse bitswang mandament transpoli. Le ha ile hore ntate Thabisha o nana le tokelo ya hore a ka o tebela, rona re tlameha ho bontsha lekgotla hore mokgwa o a o tebetseng ka ona ke tlolo ya molao. Ka bokgutshwane hore ditokelo tsa hao jwalo ka mohiri di hataketswe.
Ntate Thabisha o tlile ko fleteng a mpontsha dipampiri tse tsa gagwe. Ne ke re wa go ntshwarisa nkisa toronkong, ne ke tsogile gore
a kompolele ntate Thabisha o ile a lisa kae wena le ngwana hao ha qeta ho le tebela?
o rayang ga re isa gope ke founetse ausi le monna ga gore ba tle gore tsa re nna teng go gone anong mme ga re kgone go sala lobaka ha ke batla re a tsena mathateng le mohirisi wa gagwe.
Mama Marao ho ya ka molao ntate Thabisha o ne a tlameile gore a le batlele mo le ka dulang teng ha ebe o tlo le tebela wena le ngwana hao. Hape ho na le dintho tse ding tsa molao tse a sa di latelang.
Ha ke kgone le go duela rent ya ka ka go leboga yang
o se ke wa tshwenyeha ka seo. Moakamedi wa ka o sa ntsibisitse hore o wela hara batho ba o hlokang haholo. Seo se bolela hore ke wa hlola go kgona ho mpatala. Jwale ha ke re tswele pele ka ditaba tse ding.
Law clinics are legal services centers generally attached to various universities in South Africa. They provide a very important role in ensuring access to justice, in particular for the poor and the indigent. But they play even a more important role in helping the students to bridge the gap between the theory of what they learn at university and the practical implications of the law and of that theory. It's also important that the students, whilst at university, they must begin to understand the social context of where they are operating.
Coming up, the Law Clinic takes Lesego's case to the local magistrate's court. The Prevention of Illegal Eviction from and Unlawful Occupation of Land Act, also known as the PI Act, states that no one may be evicted from their home without an order of court made after considering all the relevant circumstances. Regarding the eviction of unlawful occupiers, the owner or person in charge of the land must send the occupier a notice stating that legal proceedings are being instituted for an order of eviction.
The Prevention of Illegal Evictions from and Unlawful Occupation of Land Act was enacted to give constitutional effect to the constitutional provision that prohibits basically forced evictions. The Act prescribes certain prerequisite requirements that need to be met. That, when read with the Constitution, as well as certain judicial requirements, lay out the proper foundation or the requirements that need to be met by a landowner in order to be successful in trying to evict a person.
Monica Douglas, a widow and young mother, was evicted from her home after her husband died and she could no longer keep up with the mortgage payments.
I got married to a guy who's late now. My husband is late, Robert Douglas. We were married in community of property. We bought a house in 1995. 2004, he died. And when he died, I wasn't working. 3 months down the line, I think it was in December, if I'm not mistaken, I got a phone from a lady in Joburg that I do not qualify for the insurance. I need to go out of the house. And I was told that around about the 16th of April, I'll be evicted out of the house. And I was like, didn't know whom to consult, where to go, didn't know really where to go.
Monica's case is ongoing. It is important for people who find themselves in similar situations to know that there are institutions providing free legal assistance to poor people who are faced with the threat of illegal eviction.
There are a number of aspects of why the legal aid South Africa end up involving in eviction matters. The groups which are affected by illegal evictions are vulnerable groups such as elderly, disabled people, children and women heading households. Firstly, the person can phone our call center, can contact our call center, then they can give a free legal advice. Then another thing is that the person can visit the nearest office of the Legal Aid South Africa to apply for legal aid. Then the person will see the paralegal, who will also check the means test, as well as, and then after that, then they will take the statement and the matter will be given to an attorney who will do the means test to check whether a person qualifies or not.
A person may make application to court for an order granting the Roman Dutch law remedy, the mandement van spolie, also known as a spoliation order. The application will be successful if two requirements are fulfilled. Firstly, the applicant must have been in peaceful and undisturbed possession of the movable or immovable property in question. Secondly, the applicant must have been unlawfully deprived of his or her possession of that property. Lesego has made application for the court to grant the mandement van spolie. But will she be able to convince the court that she should be allowed to return to the property?
I submit that Mr. Tabisha did not offer or attempt to make any alternative living arrangements for the applicant as is required by the Prevention of Illegal Eviction from and Unlawful Occupation of Land Act. The respondent took the law into his own hands when he removed Mrs. Marawa and her family from his property. It is only right and fair that she be allowed to return to the property and her belongings until such a time that Mr. Tabisha is able to lawfully process his desire for eviction as is required by the legislation that was specifically designed to deal with situations such as this one.
I submit that Mr. Tabisha had every right as the owner of the property to demand that the applicant remove herself from the premises, solely based on the fact that she had faltered to pay her rent for over a year. A time frame which suggests that the respondent was more than accommodating to her personal circumstances and which allowed Mrs. Marawa ample time to seek and to find new accommodation, knowing full well that she was unable to keep up with the payments at the said premises. As stated in the respondent's affidavit, marked Exhibit C, the applicant consented to leaving freely and even handed the keys of the flat to Mr. Tabisha. At no point was force or intimidation used against Mrs. Marawa or her child. I direct your ladyship's attention to various supplementary affidavits deposed to by members of the street committee stating that the applicant vacated the flat voluntarily and was not forcefully removed in any way.
In this case, the concept of mandament van spolie arose. It's a very old concept. South Africa got it from the Roman Dutch law principles. It has survived many legal regimes up until today, simply because people are not allowed to take law into their own hands. The basis of this principle is to make sure that people don't resort to self-help when they're dealing with disputed rights.
The respondent would have this court believe that the applicant left her home in the middle of the night voluntarily. In actuality, the applicant left behind all her personal belongings that night. That does not suggest a person accepting of their fate, but rather a person caught in a hostile situation with no other option but to flee. Furthermore, the respondent placed the applicant in a tense and hostile situation when he brought his friend along to act as a physical force. The applicant left under duress and was basically bullied into leaving the premises against her will.
Mr. Tate, what is your response to the allegations of bullying and intimidation?
I submit that there was no intimidation or bullying on the part of the respondent and his friend. The friend was simply accompanying the respondent and had offered to assist the applicant with any items that she might have needed moved. The respondent was more than patient and accommodating in allowing the applicant to fall behind on her rental payments for over a year, without taking any real action against her until now, though it was within his rights to start the eviction process from the very first time that she defaulted on paying the rent.
Ms. Campbell, Do you have anything to say to that?
If so accommodating, then why, if the applicant was already behind in her payments, did the respondent then choose to increase the rental amount the following year instead of dealing with matters when they first arose?
Mr. Tate, does the respondent have an explanation for this state of affairs?
On numerous occasions throughout the year, the respondent did request that payments be made, and later that the applicant evict the premises. But the applicant went against these legitimate requests and continued to stay at the premises. The respondent was left with no other choice.
Here in this particular case, respondent raises that the applicant left out of her own volition. But it is very irreconcilable for one to leave a property, say in this case, leaving her particular flat at night when she had only night dresses with a child. It's very hard to understand.
Coming up, will the court find that Leseho's application fulfills the requirements necessary to grant the mandament van spoiling?
Mr. Tate, did the respondent give notification to the applicant of the fact that she was behind on her rent prior the night he decided to evict her?
The respondent did give written notification to the applicant. With the same urgency the applicant has in lodging this application, the respondent has to support his family with regards to income collected from the property rental.
Ms. Campbell, what do you have to say about this notice?
I submit that the letter the applicant received from the respondent cannot take the place of an official order from the court, as required by the Constitution. There was no application to court in terms of the relevant legislation.
In instances where a person is evicted without a court order, that process of eviction is illegal.
If we look at this case before us, where is a female staying with a child, and now you see now our government it's very protective and is very lenient towards females and also the children. When their rights are affected, the court is very quick to jump.
By writing the letter, the respondent was desperately trying to remove the applicant without having to engage in what could be a lengthy court procedure, knowing full well that she was already under financial strain.
I must object.
On what grounds, Ms. Campbell?
It is ludicrous for the respondent to try to convince this court that he failed to follow the proper legal process in order to spare the applicant any further hardships. But then he chose to arrive at her house in the middle of the night to remove her and her child in their nightwear.
Mr. Tate, what have you to say in response?
If removed so harshly from her home, then why, as stated in both the applicant and the respondent's affidavit, did the applicant willingly hand over the keys to the premises? By doing so, she was physically consenting to leave.
In this case, the representatives of the landlord sought to indicate to the court that Ms. Leseho left the property out of her own free will. Indeed, I think this is a weak argument in the sense that no person will leave the property in the middle of the night. No person on her own free will would leave her furniture inside that property. And that person would not have waited for two men to come and knock onto their door to be able to leave the property. And it's also indicated by the fact that she was wearing night clothes, indicating that she was not a person ready to leave. It's important, therefore, in law that an argument that is being put before the presiding officer, or before the judge or the magistrate, must be the argument that is substantiated by the facts of the case. The weakness of this argument is that it's not substantiated by the correct facts.
The court finds the following submissions on the part of the respondent to be irreconcilable with common sense and logic. 1. Why would the applicant leave all her personal belongings behind if she had agreed to move out of the premises, as alleged by the respondent? 2. The fact that the applicant was in fact in her nightgown and her child in pyjamas at the time of eviction is inconsistent with the respondent's argument that she had left willingly, because she wouldn't have dressed in such clothes if she had in fact agreed to leave. 3. After the eviction, though in financial strain, the applicant still sought assistance from the University Law Clinic to launch this application so as to vindicate her rights. She would not have done so had she truly consented to leave. The respondent failed to attempt to arrange alternative accommodation, and during the eviction, he brought with him a friend. This man had no personal connection to the situation, but acted as a physical force in a tense situation. This court, therefore, does not accept the respondent's defense that the applicant consented to leave the premises. Further, in this case, the alleged consent in fact amounts to a waiver of constitutional rights, namely the right to not be evicted without an order of court. This court finds that the applicant complied with the 2 factors required for granting of a spoliation order and has proven her case on a balance of probabilities. The court therefore grants mandaman van spoilie. The applicant is granted the right to return to the premises until such a time the respondent follows the proper legal procedures in terms of the Prevention of Illegal Eviction from an Unlawful Occupation of Land Act.
The mandaman van spoilie provides temporary relief in circumstances like in the present case, because the actual dispute has not been dealt with. Firstly, the issue of ownership, and secondly, the issue of non-compliance with the agreements, with the agreement or lease agreement. So what then will happen is that a person in the position of Mr. Tabisha, that is the landlord, will be able to go to court and firstly prove that he is the owner of the property, secondly prove that there was an agreement between him and Ms. Lesejo, and thirdly that Ms. Lesejo has breached that agreement, and therefore he requires the court to issue an order giving Lesejo a date in which she has to vacate the property.
Landowners should be cognizant of the procedure as set out in PI. Obviously, failure to do so does carry criminal sanctions. An illegal eviction is a criminal offence, and one may be prosecuted either by the National Prosecuting Authority or, should the National Prosecuting Authority decline, through a private prosecution by the occupier, him or herself.
A court may only grant an order for eviction if it is of the opinion that it is just and equitable to do so, after considering all the relevant circumstances, including the rights and needs of the elderly, children, disabled persons, and households headed by women. If you need assistance regarding an eviction matter but do not have money to pay a lawyer, contact Legal Aid South Africa, 0800 110 110. The final verdict was brought to you by SABC together with the Department of Justice and Constitutional Development.